Good afternoon, good evening, or good morning, depending on where you're watching. Welcome to another edition of Crime Time with DutyRon, a retired New York City police detective with 20 plus years of law enforcement. And if you like all things true crime related from a police perspective, please hit that subscribe button, hit the notification bell, so you will get all things DutyRon when I go live or upload another video. Tonight, I have a special, very, very special panel of real professionals. I have Linda from It's a Crime. All of you love and know her from up in Canada. She has a great true crime show where she gets down to the facts and she gets right into it. I will be introducing her in a few moments. And thank you to all of her subscribers and all of her fans who we all intermingle with because we got great communities. Thank you for all of you guys for coming on over here. I also have a retired federal, state, and local prosecutor. He is on board with us tonight, and he was kind enough to give us his time. Pete Carusco and Joe Murray, criminal defense attorney. He is here with us here tonight. But before we get into it, I want to say a special thank you to all of my Patreon supporters, my channel members, and everyone who positively engages in this community. You guys are instrumental to making this work. And I say thank you to each and every one of you for your respect and your dignity that you show throughout each show that I produce and put out for you guys. It is really an amazing thing to watch. And I'm very thankful for you guys. We also have Suzanne Morphew's stepbrother, Tommy Owen. He is here in the chat with us and backstage. He will be joining us as well. We're going to answer a lot of questions in regards to Barry Morphew's case, the arrest warrant affidavit. This is something that is getting everybody in a tizzy, and it's for good reason. We all want answers. We want to know where the prosecution is going, where the defense is going, what is going on with this case. So it is really, really interesting, and it's something that we got to get into quickly. And we have the right folks here. So I'm going to share with you quickly a little bit of the arrest. This is basically the arrest day. This is the arrest day. I'm not going to play the whole thing, but I want you guys to hear it. So let's get right into that quickly.
Up? Okay, yeah. All right, I'm Chaffey County Sheriff John Speasy. We're going to go ahead and get started. I'm going to read you a prepared statement, and then we'll introduce our district attorney and take questions after. Good afternoon. I wanted to thank you for traveling to Chaffey County on such short notice for today's briefing. Before we begin, I just wanted to speak briefly about Suzanne. I have to admit I did not know Suzanne personally before the beginning of the investigation, but now I feel I've gotten to know Suzanne quite well. I have learned that Suzanne loved her two daughters, Mallory and Macy, deeply, and there was nothing she wouldn't do for them. I've also learned that Suzanne had a passion for life and lived it to its fullest. I've also learned that Suzanne was very easy to like and was cherished by her closest friends. I believe people like Suzanne are a rare find, and those who knew her were indeed very lucky. Today marks a major milestone in this investigation of Suzanne Morphew's disappearance. We're announcing that at 09:15 hours this morning, the Chaffey County Sheriff's Office arrested Suzanne Morphew's husband, Barry Morphew. He was taken into custody near his home in Poncha Springs. He was alone at the time of his arrest, and he was arrested without incident. Today marks the culmination of thousands of hours in this comprehensive investigative effort to locate the mother of two who went missing May 10th of 2020. More than 70 investigators from the Chaffey County Sheriff's Office, the Colorado Bureau of Investigation, the Federal Bureau of Investigation, and dozens of other local law enforcement agencies have provided their expertise on this case. We've executed more than 135 search warrants across Colorado. We've interviewed more than 400 individuals in multiple states. Our team has also investigated more than 1,400 tips generated from within and outside of law enforcement. In early April, the extensive work completed by our investigative team was presented to the 11th Judicial District Attorney's Office. In that multiple-hour presentation, we outlined all of the information and evidence we have taken in over the past 12 months. Following that meeting, the district attorney's office reviewed our case and information and solidified their decision to move forward on this case. Today is not the day for celebration, nor does it mark the end of this investigation. Rather, it's the next step in this very difficult yet very important journey as we seek justice for Suzanne and her family. I know how deeply this case has impacted our community over the past 12 months. Through multiple conversations I've had with our citizens across the county, one message was clear from everyone, and that's that they wanted answers and they wanted justice for Suzanne. Although I'm not able to offer specific details, I want to assure the community that every action our investigators took in the past year led to today's arrest. This arrest would not be possible without the assistance of our supporting law enforcement agencies, which include the Colorado Bureau of Investigation, the Federal Bureau of Investigation, and of course the 11th Judicial District Attorney.
My name is Linda Stanley. I'm the District Attorney for the 11th Judicial District, which includes Fremont County, Custer, and Chaffee counties total. I wanted to say that thanks for being here for everybody, and there's a couple of things I'd like to address about this case. First, the investigation is still ongoing. Suzanne, her body has not been found, and we're still looking into that. The investigation is ongoing. Second, Barry Morphew is presumed innocent until proven guilty. That's important to remember. Third, the arrest affidavit is sealed at this time. I cannot and will not discuss it. Fourth, all media inquiries from this date forward should go through my office. However, I'm sure you all are aware and know that we cannot talk about any open or active investigation, and that is per the rules of professional conduct that we will abide by. Lastly, I wanted to say that today is a good day. It's a good day for all of the men and women in law enforcement that have tirelessly worked toward getting here. They worked day in and day out, sacrificing more than any of you will ever know. They even continued working and continued their sacrifices as they were being raked over the coals and second guessed as to their skills and abilities. I'm standing here in front of you on this good day because they never quit. Sheriff Speasy and his deputies at the Chaffee County Sheriff's Office, Alex Walker, investigator for the 11th Judicial District, those two individuals in Sheriff Speasy's office in particular are consummate professionals and, quite frankly, some of the best I've ever worked with in my entire professional career. They followed every lead, every tip, and every unanswered question, no matter what direction it led them in. They never compromised the integrity of the investigation. On several occasions over the last few months after I was sworn in on January 12th of this year, I met with these professionals and went through hours and hours of their meticulous investigation. Their investigation was presented to our office just a few weeks ago. For me, today is a good day, but for my office, this is where the work begins. There's more work to be done. However, this is an important and incredibly crucial step. And today is a good day for Suzanne. As far as I'm concerned, today is all about Suzanne. And it's about her family. And it's about all the individuals that knew her and loved her and cared about her. That's what this day is about. And it's a good day. Thank you.
Okay, ladies and gentlemen, I wanted to play that because I thought it was very important. I thought it was important on many different levels. For one, it was all about Suzanne. Day one on that arrest, 360 days of investigation. I tip my cap to the men and women of law enforcement, state, local, and federal, who worked tirelessly on this case. So kudos to my brothers and sisters in blue. Without further ado, I want to introduce to you some of my guests. There's quite a few, and I have a few waiting to come in the green room in the back. But first and foremost, I want to introduce Suzanne Morphew's stepbrother, Tommy Owen. thank you so much for being in here. And you've got your mic still muted. I don't know if I did that or you did it.
No, I did that, Ron. Thank you. Yeah.
Tommy, you got a cat with you. Good to see you,
Yeah.
brother.
Good to see you, man.
Thank you. I'm going to introduce my next guest, Linda from It's a Crime. She covers your sister story and many other stories with respect and dignity, and she digs deep into the facts. And this is why I love her. She is Linda from It's a Crime. She's right here with us. Thank you, Linda.
Hi, everyone. Thank you for having me on the show.
It's my pleasure. It's an honor, actually. So thank you. My next guest is a former prosecutor on the state, local, and federal level. He is Pete Crusco. He is friends with Joe Murray, our criminal defense attorney, who I'm going to bring in really quick here. There he is, Joe Murray. Thank you for introducing me and my audience to Pete, the prosecutor. I know we all have a lot of questions, but before we get into it, I just want the folks to know what we're going to cover is the arrest warrant affidavit and the prosecutor's side. We already got the criminal defense attorney side from Joe many, many times, but we are going to cover the prosecutor's side. We're going to get into Pete's head and ask him some of the tough questions about this case. So I'm going to ask right away, get right into you, Pete. What is the thinking of a prosecutor in a complex case like this?
Well, usually you want to keep the investigative leads and the discussion of them to a minimum. Usually you want to keep all your options open. You want the witnesses to feel comfortable, so you don't want any discussion concerning who they are, where they live, and the like. And anything that would indicate that or demonstrate that, such as the warrants, such as the search warrants and the like, you want to keep any access to that to a minimum.
Right.
That's the usual situation.
You know, we talk about keeping everything close to the vest. And Linda, I know this drives you crazy when police officers and investigators say, hey, we can't, due to, the integrity of the investigation, we have to keep it close. And all of our viewers and all of the crime buffs and the enthusiasts out there, it drives us crazy when we don't get those answers, right?
Yeah, I mean, I completely understand why. I'm just the super nerd when it comes to timelines and the details, right? So obviously, I'm in a little bit of a pickle when I don't have the case, but
Yes.
it's just because I'm a nerd for truth and knowledge. So
right. And when I talk about this case and when we all speak about it from our professional standpoints, we know from a detective's point of view. I did the job for over 2 decades. I know what it takes to put together a case and then bring it to the prosecutor's office. They look it over and they go over it with a fine-tooth comb to make sure that they can bring a case forward to not just get a summary arrest. They want to get a true bill indictment, and then they want to get a guilty verdict at trial. So no prosecutor wants to bring a case forward if they don't think that they can get a guilty verdict. Isn't that correct, Pete?
Absolutely. But you have to remember, when we're at this stage of the proceedings, for purposes of an arrest warrant or a search warrant, the standard of proof is not beyond a reasonable doubt. The standard of proof is probable cause. That is reasonable cause to believe that a crime was committed and this person committed the offense. That would be the standard for an arrest warrant.
Right.
The standard for a search warrant is probable cause. Once again, reasonable cause to believe that a crime was committed and this location that you want the search warrant for, or these documents that you want the search warrant for, or this location where a body may have been transmitted from or transported from, there is evidence to believe that evidence of a crime could be found there. So it's not proof beyond a reasonable doubt. Additionally, when you're writing up a search warrant, all right, many times you will get information from various sources, and you will put it all in there because the more the better. And should that search warrant come out improvidently, the sources of that information will be disclosed, and certain avenues of further investigation may be hampered because people will say, hey, the DA's office disclosed, that now they know where we live, now they know what we said to certain people, now they know who we talked about. So it will have a chilling effect on the success of the investigation.
Yeah, Pete, I got so excited that we had you here. I skipped over your illustrious career. I want you to quickly let I want you to let the audience know about your 40 years experience. Now, Joe Murray jacked up your time to 42 years, and he led me on. So that's
Well,
what.
he's a defense attorney. That's what they do.
Hey, you took the words out of my mouth. That's what any good defense attorney does. He leads you right in. But tell the audience listening here about your experience. 40 years in the business of the prosecutor's office. You worked for the illustrious Richie Brown. Uh,
Yeah.
Talk to the audience about what you did and how you
Well,
started.
I was lucky enough to have a career doing something I wanted to do. I used to go to the Queens County Criminal Court when I was a teenager, sit in the back room and watch the cases. And I said, this is what I want to do. And went to law school. I did very well in there. I got a job with the appellate court. They had me reviewing all their briefs. So I got to review convictions after trial. And, my job was to analyze those. I worked for the Pittsburgh DA's office, and then I worked with the Attorney General's office and the U.S. Attorney's office. And my most time was spent at the Queens DA's office, where I worked for the legendary Richard A. Brown, who appointed me the chief of investigations. So my responsibility was to review all major investigations in Queens County, reviewing all the wiretaps, the search warrants, the cell site orders, going over all new and cutting edge technology, making sure it complied with the Fourth Amendment. And I also kept a caseload of my own, because I felt that unless I kept in contact with the police officers and investigators, I'd lose touch. So, for 40 years, not only was I a supervisor, but I was also in the trenches with the cops, working cases, and many of them major cases. I was a special prosecutor for Suffolk County and for Kings County, and many sensitive investigations. So I have a vast, type of experience that not too many people have. And in the end, I was the longest tenured chief of investigations in New York City history. Very proud of that. And but for my family allowing me to do all this and their sacrifices, I wouldn't have been able to spend 40 years doing this. So that in a nutshell is it.
I got to say, I'm honored to be in the same panel on the same live stream with you. I'm really honored.
That's very kind of you.
I want to say, Pete, I know what you guys do. The Queens County District Attorney's Office is one of the busiest right around Manhattan. It's right second to Manhattan with cases, maybe even more. It's a large geographical area. So I have worked and wrote up many search warrants with people from your staff over the course of time, and have been in and out of Queens Supreme Court and criminal court. So
remember you're a very active detective.
Yes, I was in and out of there with my confidential informants and doing all kinds of secret squirrel search warrants for drugs and guns. We took so many guns and drugs off the street of New York City. I'm telling you, your office were nothing but consummate professionals. And again, I tip my cap to you and all of the men and women that work in the Queens County District Attorney's Office.
Well, thank you. It started with the top with Judge Brown. He was the consummate professional, and absolutely, he's the one that got through the credit.
Absolutely. And Joe Murray, you got an interesting story with Pete. Why don't you talk a little bit about your starting out with Pete for the folks that are watching?
Yeah, it's such an honor, and our paths crossed when I was in law school, and I went to go do my first internship at the Queens District Attorney's Office. Remember, I went to law school after I retired from the police department, but I ended my career in the police department in Queens County. So I was familiar with some of the DAs and judges, and going to law school, I wanted to be a prosecutor, and working in the investigations division was like a dream. So they assigned me to investigations, and I got to work with the chief executive in the investigations division. It was such an honor. We worked on, and Pete is right. He did not just was an administrator. He was hands-on, dealing with very sensitive, confidential cases in court, writing papers, motions, and I got to take part in that. So I had a wonderful experience with Pete. We remained friends over the years. I tried to get into the office. However, I don't know if you remember this, Pete, I made it to the executive round. I was so excited I was going to get in, but the New York State has a double dipping law. Because I already have a pension from the police department, I was not able to join the district attorney's office because of the double dipping rule. You're not allowed to be a part of two pension systems. So I couldn't take the job, and I told
And it was
them,
our loss. It was our big loss because you
I
were.
said, you're going to force me to go to the dark side, and then that's what I did.
But Joe, you did what you could. You tried to get in there, and that's all part of a law enforcement professionals. We have it built into us. It's a life calling. You know, we do.
Yeah.
Listen, I'm doing this after I retired. Let me reel this in real quick because I want to focus on these 5 charges that were in here. It's first-degree murder. I want you to take us through these, Pete. And I know Linda, she's just chomping at the bit. She wants to get her questions out to you, Pete. But we got first-degree murder, tampering with a deceased human body, tampering with physical evidence, possession of a dangerous weapon, attempt to influence a public servant, and voter fraud. You want to take those one by one and give us?
Well, I'll give you the brief overview. Murder in the first degree is essentially intentional, deliberate murder, as opposed to manslaughter, which would be negligent. Okay, tampering with the deceased body, there must have been some type of effect with respect to the deceased body, and they have sufficient evidence of a tracing or tracking of it, or some type of DNA that would indicate that it was moved from one place to another.
Can I stop you on that? Okay, because that's a sticking point for me. You know, we do have her stepbrother here, and Tommy knows that we were going to speak about these sensitive topics because that's why he's here. He's got questions to ask you as well. When you talk about tampering with this deceased human body, you briefly scathed over that. Now, this could mean something from an article of clothing with blood on it or DNA. It could be a burial site where DNA was recovered, but there has to be substantial evidence for them to charge that charge, correct?
That's correct. I mean, the statute indicates that either it was destroyed, mutilated, concealed, removed, or altered in some fashion. So there must be some evidence, and it could be circumstantial as opposed to direct. There may be no witness to say anything, but perhaps they found, clothing, perhaps they found trace DNA or the like that would give them sufficient to charge us. And once again, the charge only needs to be prima facie, only needs to be probable cause standard. When you get to trial, you'll have to prove it beyond the right reasonable doubt. But for purposes of charging someone, that's the standard.
Linda, you want to jump in?
Yeah, I have a question about that.
Okay.
So the example, could it be, say, cadaver dogs hit in an area, found something, maybe perhaps they found something in there, and that would pertain to that charge?
Correct. If the dog can be qualified such that with respect to the DNA, that is indicative. Now, would that be sufficient? Probably not. You'd want a lot more than that. All right. So, but that would be probably part of it.
Little
Yes.
piece to the puzzle. Okay.
Yes.
Thank you.
Sure.
Okay. Let's continue on with the rest of the charges.
Okay. Tampering with physical evidence. Once again, that would be similar. It would be in a similar vein, but not with respect to the deceased body. It could be with respect to any type of evidence that would pertain to that. It could be clothing. It could be fingerprints. It could be whatever might have been tampered with. As far as the statute, let's see what it says. Unlawfully destroyed, mutilated, concealed, removed, or altered physical evidence with intent to impair its verity or availability. So as you see, the language is similar. The only thing that's different is that it doesn't talk about the deceased body.
Yeah. Yeah.
Now, with respect to count 4, the possession of a dangerous weapon, they have that charge concerning a short rifle. That might be a throwaway. They might have found that during a search warrant, or it might have been implicated in the case. You don't know at this point.
Now, Pete, I don't mean to cut you off. I initially, when I read this, I thought sawed-off shotgun in New York City. If someone has a long gun and then they cut it down, you can have a charge like that. I just want to clear it up for other people because I get so many messages into my website. I want to make this clear. What are we looking at here with this with this charge?
Well, usually it would mean similar to a sawed-off shotgun, but without more specifics in the charge itself, we wouldn't know. What we would really require is a bill of particulars. If I'm the defense attorney, I'm sure Joe would tell you that the first thing I'm going to ask for is a bill of particulars with respect to all of this to find out exactly, what the gun was,
Right.
and that would answer your question. But
Okay.
without knowing that, I would be speculating.
Right. And that's the sticking point, is that a lot of this stuff is not being released. And talk about, just before we continue with this, just give a brief overview of some of the reasons why, say, the prosecution might want this information to be out or might not want it to be out, and talk about the defense would fight with them for this.
Well, look, in most of my cases, I would not want the evidence to get out prematurely. And most of the time, that's because I was dealing with witnesses who really didn't want to come forward, informants who were in danger, family members who may be compromised, and also in similar situations, it causes a lot more havoc for the police department, because then not only you have to deal with investigating the case, but you have to deal with the personalities and the needs of people that you might have caused to be aggravated because of you disclosing the information. So you have to balance things very carefully.
Yeah. So go ahead, Linda.
I have two questions, actually, just from what you're speaking of. The bill of particulars that you're talking about, is that also, from my understanding, can come from the 11-day search that they did, the search warrant on the house? And so when that's complete, they do a bill of particulars. Is that correct?
Well, what usually happens with a search warrant is that the prosecution has to turn over a copy of the search warrant. If they believe that there's sensitive material in the search warrant, they can ask for the court to redact it. The court can redact certain matters as long as it's not going to infringe upon the defendant's right to a fair trial. It's what's called, in New York, an al finito hearing. In the federal system, it's called a Franks hearing. An al finito or a Franks hearing allows the defense to contest the credibility of the police officer affiant who is the applicant for the search warrant. Usually one police officer is the key lead investigator, and he's the one who drafts the search warrant application with the help of the prosecutor. Now, they've already disclosed there's 135 search warrants. My question would be, is it 135 separate search warrants with separate applications, or is it one application with 135 search warrants? This is probably a truckload of documents, what we call a document dump that could eventually occur at some point during the proceedings. But all the evidence that the prosecution has is generally subject to some defense motion or hearing. And it's in the prosecution's best interest usually to delay notification until they know exactly what the story is, and until all the witnesses are, whose legs may be like spaghetti right now, firm up. So now, on the other hand, why would the prosecution want to disclose all this? Well, if they need to convince the public out there, because there is some circumstantial evidence and there's a lot of connections and a lot of links, which will be difficult. Perhaps they want to sell their case to the jury, before the trial. Now that is touch and go, because the right to a jury trial, the right to a fair trial, is paramount. The defendant's right to a fair trial takes control over the public's right to know. So, if I'm the defense attorney, I'm going to be taking in all this media hype and starting to prepare a motion to change venue so the case gets tried 200 miles away.
That's what they don't want. Hey, I got to interrupt just for a second because I have someone who doesn't have a lot of time. Laure Scharf from Fox 21 is here. I'm going to add her in now. I'll introduce you guys to her when I put her in on here. Laure, thank you so much for taking out some time and coming and spending a few moments with us.
Thanks for having me.
Yes, it's an honor. So I have myself, I have Linda from It's a Crime. She's up in Canada.
Hi, Lauren.
Yeah, it's Linda. And then Pete Crusco is the retired prosecutor. You heard him take
Hi,
over.
Lauren.
Hello.
I have my criminal defense attorney right next to you, Joe Murray. And Tommy Owen is here. That's Suzanne Morphew's stepbrother. I'm sure you know him.
Hey, Lauren, thank you so much for all you've done.
Oh, well, thank you.
From the family, thank you.
Uh-huh. Thanks.
So, Lauren, you have any questions? I know we spoke briefly on the phone today. Anything for Pete, former prosecutor?
Well, just Pete, real quick. Thanks so much for coming on here. Just a couple questions. Have you seen a case where a judge keeps an affidavit sealed until trial?
Yes, in fact, I had a lot of those type of cases, especially with the Cali and Medellin cartels, organized crime cases. I mean, that would, as I indicated earlier, most of my cases I would ask for matters to be sealed because I was afraid of witnesses being tampered with. I was afraid of evidence. I was afraid of investigative techniques being disclosed. So this is nothing, unusual. In sophisticated cases in which there is a potential of witnesses or evidence being tampered with.
Okay, you touched on it a little bit about, since Salida is such a small town, do you think it would be in best interest of both the prosecution and the defense to have the case tried in another venue?
Well, that would depend upon how much the media hype grows. I mean, let's look at it this way: if the judge were to call in 100 jurors in the initial jury pool, and if he or she starts asking questions about, could you be fair in this case? Could you put everything aside that you've heard and be fair and resolve the case just upon the evidence that you hear in the courtroom? And if the first few of those trial jurors start saying no because we've heard so much and we've listened so much and we see everything on our iPads and all that sort of stuff, well, then you're looking at moving the case 200 miles away or whatever, and that's going to cost the state and going to cost the witnesses, and going to cost the case, in the long run.
Mm-hmm.
So, the controlling the amount of media, exposure here is in the best interest of having a fair trial. Mm-hmm. That's, I really can't see a situation where it would not be in the best interest. I mean, if you keep things as under control as you can, you'll wind up with a trial in a county of the defendant's peers. Otherwise, it's going to be shipped off somewhere where that's going to be at issue.
I don't know if you can answer this or Mr. Murray. Once this does go to trial, Barry, he avoided the media for a year. And so what is your guys' opinion on whether or not Barry takes the stand?
Joe, you want to handle that?
Yeah, it's very rare that a defendant would take the stand because the burden is on the prosecution, and the burden is, like Pete alluded to, beyond a reasonable doubt. The defendant has to do nothing except say, I'm not guilty. And the prosecutor has to bring all their witnesses in. And as a defense attorney, I cross-examine them. I look for holes in their case. And I try to, expose the possibility of credibility issues. And the defendant rarely will testify unless there's an affirmative defense that the defendant would bring forth, like a justification defense or entrapment or something like that. But I don't know if we're going to see him testify. It depends really what the people's case is and what the evidence is.
Mm-hmm.
Yeah. I had an old-time teacher when I first became a trial attorney who told me it doesn't matter what happens at a trial. If the defendant takes the stand, the case has started anew, and the whole case is in play once that defendant takes the stand. Doesn't matter how good you were before, how bad you were before. Now, game time.
So, in your 40 years experience, Pete, the percentage of defendants taking the stand and testifying is very low. I mean, that's what I'm getting from you.
Yeah, less than 10%. But I got to tell you, it was game time every time they testified, and I used to love it. When I heard that they were going to testify, I used to love it because I would do I would do untold hours of research, getting every bit of pieces of evidence and bad acts or whatever, to be ready to cross-examine the defendant. And most of the time, it's stayed in the file until sentencing, where it might be admissible for purposes of sentence. But rarely did I use it unless the defendant took the stand.
You know, I just want to add something to that too. Peter, I'm sure you'll confirm this too. The standard of proof in a criminal trial is beyond a reasonable doubt. It's such a high burden. In a civil case, the standard is a preponderance, 51%. Is it more likely or not that the defendant is guilty or responsible? So what happens, and I've seen it happen, when a defendant takes the stand, it seems to automatically reduce the people's burden because they go like this. The jurors start weighing it and say, I don't know, he seems a little shaky, or I don't know, that other witness is really sure. And it becomes a preponderance case. It's a real danger to have your client take the stand because that's a natural reaction that people will start weighing. Oh, I think he's guilty. If he didn't testify, they might say, I think he's guilty, but they haven't reached that beyond a reasonable doubt burden. If he testifies, you may give them enough.
I agree. Absolutely.
Any good defense attorney is not going to let their client take the stand, especially in a case like this. And Barry, as we all know, has procured 2 go-getters. Lauren, you want to talk a little bit about that? Some of the people might not know these 2 attorneys that Barry retained.
Yeah, I've only interviewed 1 out of the 2. I've interviewed Drew Nelson, and she represented Crystal Lee Kenny, who she was the mistress, you could call her. She was a former nurse in Idaho who helped clean up the murder scene for Kelsey Barrett. Well, Kelsey Barrett is the one who was murdered, but it was Patrick Frazee. Yeah, there's Drew Nelson. You can see her there. And the other attorney, her name's Eaton, Iris Eaton. Or I hope I'm saying that right.
Yeah, I think you're close. You're pretty close.
Yeah. But they've worked together for many years, and you can see.
I'm not trying to make it bigger.
You're fine.
Hold on.
I'm curious to know if they're doing this pro bono, like if they called Barry or if Barry called them. I'm not sure exactly.
I don't think we'll ever get those details, but
I'm curious about that as well, Laura.
Mm-hmm.
Solicitation is unethical. You're not supposed to solicit.
Okay, let's talk about that. Let's talk about that, Joe. So an attorney to go and solicit a client that is being charged and has already been represented by 18B or legal aid, as Barry was represented by a lawyer from the court, I believe, in his initial appearance. It's an unethical thing. Talk a little bit about that so we understand it.
Yeah, I mean, for attorneys to go out and solicit, the rules are pretty strict on that. However, if this is a pro bono situation, I didn't know that. Are they representing them free of charge?
We don't know. Lauren had just mentioned that, and Tommy doesn't know either. No chatter from Andy or anybody from the other side?
No, but I agree with Lauren. These 2 were top guns. They also, there was a case that they got a gentleman off for supposedly his wife committed suicide on New Year's Eve. I believe it was ex-law enforcement. Tom, I forget his last name. And they got him acquitted on that case.
Yeah, I would be curious to hear of how they got that acquittal. And that had to have been something with a messy evidence collection, Pete.
Yeah, but they know what they're doing for sure.
Yes.
They're top guns. So back to the original question, we don't know. We do know that he sold the house for 1.5, I think. So it's interesting timeline, don't you think, that the house was sold and then It's almost like he was planning to either have the money to go or to have the money for defense.
Right. Yeah. It seems like he was trying to plan some type of financial
Again,
gain.
I don't know that that's the case. Let me be clear. I'm just saying it
Of
is
course.
interesting that the timeline shows, not only, did he not help in the search, then he sells the house, and his excuse was because he didn't feel safe for his family, which, okay. But it also gives him some cash to work with for a defense thing. And he's going to need all of it for those two.
Right.
In my opinion.
Yeah, I mean, Tommy, it's when you're looking at it from the outside and when you're looking at it from where your point of view, it just seems all very planned and
I mean, Joe, you can speak to this. What's the billable hour for a Top Gun attorney? An hour?
Oh, it depends on jurisdiction. I couldn't even guess what out in Idaho what they would get. But I got to tell you, I don't know if it's fair to accuse them of soliciting. I think it's a natural thing to look for an attorney who's had success in the area that you're finding yourself in trouble with. And also, the fact that they're women, that's not a terrible idea. When you're, they're couching this as a domestic violence situation. And having two women going to bat for him in his defense vigorously, it could be persuasive. I don't think it's something that he wouldn't have come up with himself or other advisors to him to seek out these people.
Joe, what's your rate in New York per hour, may I ask? Because I know you quoted me $550 because...
Yeah, it depends on the matter, but yeah, litigation is between $400 and $500.
Okay, but that's in New York. I mean, it could be something different for in the middle of the country.
Yeah.
I know Los Angeles, you get top dollar. You're getting top dollar down in Miami, all the major cities. But we're not talking about somewhere, major league here. So probably in a realm of around $200 to $300, $350 an hour would be, that rate. I think I would want to think. But at the end of it all, I think once the trial commences, will that information come out? Will that be available to the public for the family, for people to know? Is he paying this guy, Pete?
No, that's definitely not. That's privilege. That's
usually not disclosed.
Yeah,
so that'll be something that we'll all never get.
It doesn't have to be hourly either. Like a lot of times I'll charge people by landmark. We settle a case up the trial. If we do a trial, it'll be another fee, because it gets a little monotonous when the clients, and I've had this, where they're trying to cut down their billable hours. So they wait until the court appearance because they're paying me for the court appearance, and they dump all kinds of stuff. I'm like, why didn't you tell me this weeks ago? But
Tommy, correct me if I'm wrong. I think the real question and what we are all thinking, and correct me if I'm wrong, is I think we as good common folk are saying if he sold off properties to fund his defense thinking he was going to get caught eventually, how is that right? Is that he could spend their proceeds from his home and her home, and he allegedly murdered her. How can he get away with spending that fundage that he sold off the property to fund his freaking legal bill? And that's the best way I could put it without me.
It's an easy answer. It's a very easy constitutional answer. We have a presumption of innocence.
Well, that sucks.
If there was some civil litigation, there are provisional remedies like attachment where you can attach assets. So if somebody was going to bring a wrongful death action, they could go after and seize his assets right away.
Right.
But without that evidence, it's going to be hard to do. And only the prosecutor has the evidence right now.
Yeah, there have been cases in which we would seize the assets, all the assets of the defendant, so that he had no access to any money to pay for his attorney. And then his attorney would make an application to the court for freeing up some of those assets to, in fact, pay his legal bills.
And that is permitted, legal bills and living expenses if he's
absolutely
not.
But now, why would the prosecution freeze up a defendant's fundage? In what cases would that come in? Are those murder cases, or?
Well, in some of those cases, it could be a murder case in which you also add money laundering charges and the like. In some of the cartel cases I handled, the subjects you're also involved with laundering, huge proceeds of narcotics,
Right.
as well as, murdering people. So we would freeze all their assets. And then they'd have to go to court to unfreeze it to pay for their legal expenses and for living expenses.
Right.
We also have the Son of Sam law, which is not what you think it is. It was amended, and it was amended after the murderers of Eddie Burns, the police officer who was assassinated in the 106. His killer was in prison and won a civil rights lawsuit where he was going to win about $300,000. So the legislature went back and amended the Son of Sam law to include the ability to seize the assets of any criminal defendant who is charged with, I think it's a B felony or violent felony, and they'll seize them and hold those assets for a period of 5 years to allow the victims to then go out and file a lawsuit, because a lot of times the victims don't pursue any civil remedy because the defendant is indigent and he's in prison and he's never going to get out. So there's no payoff to a lawsuit. But when a defendant comes into money like that, the state will now hold the money and seize it and allow the victims to go sue. So I don't know if the Son of Sam law has been amended in that jurisdiction, but that's a great tool for victims.
Right.
If you remember in the O.J. Simpson case, even though O.J. was acquitted of the murder, he was found liable in the civil case it brought against him, and all of his assets were seized. So,
and that's that different burden. The criminal burden was found not guilty by a reasonable doubt, but guilty by a preponderance in the civil standard.
Right.
If there's to be a civil suit, like a wrongful death suit, is that when his assets would be frozen?
Well, that. Usually, the civil matters tie into the criminal and follow them because the prosecution doesn't want civil proceedings going on at the same time. But yet, that would be another opportunity. Yes, that'd be. I'm not familiar with the forfeiture laws in Colorado, but most across the country, the forfeiture laws have been dampened recently. So I wouldn't be surprised if the forfeiture laws are not favorable to the prosecution, and therefore forfeiture of assets is not as amenable as it could be.
Yeah, there was a recent Supreme Court case that limited the forfeiture or narrowed it.
All right, folks, I just want to quickly say hello to a couple of folks in the chat. There's over 1,000 people here, and I've been kind of just concentrating on this content. And I hope you folks in the chat understand that we have important stuff to talk about here, and it's for everybody's benefit. But I do want to say hello to all of my moderators, the Patreon supporters, the channel members, and all who positively engage. So thank you for each and every one of you for coming on in here. I see Dawn Marie. Quite a few folks have given super chat. Anna Elise, thank you for the $15 super chat. Quadruple threat tonight. Awesome panel. Much love. Thank you so much for that. I appreciate it. And anyone who I have missed during the course of the super chats coming in and things of that nature, I'm sorry. Bitsy Boo, what a cute name. Thank you for the super sticker. I appreciate you. Again, not intentional that we're kind of ignoring the chat. At the end of this, I'm going to go and look in my questions folder, and I know that I have a bunch of questions. Pete has agreed to do a quick session, about 10 or 15 minutes of questions. I see the folder is filling up quickly. If you guys aren't on my Discord server, go over there, and there's a question folder. I'll be picking out some of the questions to ask at the end. Tommy, you have anything? Lauren, Linda, anybody?
Yeah, I have a question for Pete.
Okay, great.
Hi, Peter. How are you?
Good. How are you?
Good, thank you. Doing as good as we can.
I'm very sorry about your loss.
Thank you. I had a question about the order motion to suppress the affidavit. The judge gave the order. He said that there was a big portion of the affidavit that didn't have anything to do with probable cause. And he wasn't even sure if some of this information could be entered into the court by the rules of evidence of Colorado law. I find that a little concerning. Can you comment on that?
Yeah, well, here's the thing. In a normal case, okay, an affidavit should be narrowly tailored. All right. If the case is overwhelming, compelling, the evidence is usually narrowly tailored. But when you have a case in which you have not found a body, and in which the investigation has gone on for a year, and you have 1,400 leads and 135 search warrants, I would probably guess that everything but the kitchen sink is in that affidavit. And the judge who reviewed it didn't parse it out, read the whole thing and made a final determination as to whether or not there was probable cause. That affidavit as a whole would not come in at trial. It would be parsed out based upon admissibility of the evidence through different witnesses. So that's the usual situation when you have a complex, expansive investigation.
Yeah, he said it's the biggest one he's seen in the courts for 30 years. The most detailed affidavit that they've seen in the court for 30 years.
Well,
would you say that they would use that affidavit like as a template for each of the subsequent search warrants that they went to get out? Like, they're not writing new affidavits except for if they have to tailor it to a specific area that they're searching. I think they're going to use that as a boilerplate. Would you agree?
Well, it could be a boilerplate, and it could be a situation where they have exhibits of the different affidavits attached. They might know. Look, if I was writing an affidavit, I certainly wouldn't want to create inconsistent statements. So I would attach the affidavit for search warrant number 1 as exhibit number 1, attach the affidavit for search warrant number 2 as exhibit number 2, and therefore I wouldn't be rewriting, and that would make the affidavit itself pretty bulky. So you don't know whether it's the affidavit as a whole, or whether there's exhibits attached to it that increase it significantly. Cutting and pasting is not a good thing when you're a prosecutor because it leads to errors. So many times a prosecutor would attach previously issued affidavits of search warrants to the present affidavit they were applying for. So you get pretty low. Some of my search warrants were 1,000 pages. So 135 pages is not breaking any records.
Yeah, particularly, we left out that Queens County has more wiretaps than I think the other 4 boroughs in the city, right?
Well, Queens there's a federal report every year where it's a report to the Judicial Conference. Every state has to report how many wiretaps were issued the previous year, and Queens County for the last 20 years was always in the top 3 in counties across the country. There's only about 40 counties across the country that are noted in that report. Doing wiretaps is not a pleasant experience. It's very, very tedious, and you have 30 days that has to be extended every 30 days. So you're working 24 hours, 7 days a week, usually on a wiretap, and the law is quite specific that if you mess up, you're going to lose the whole investigation. So you don't go down that road without thinking through things in advance.
Hey, Lauren, I have a question for you. I don't know how long you've been reporting in that region, in that area there, but have you seen any cases on this of this magnitude in the time that you've been reporting?
Yeah, I mean, the Kelsey Barrett murder investigation was pretty intense, but he was arrested months after she went missing. It wasn't like a year, like Barry Morphew was. Gannon Stout, he went missing in January, and she was arrested. The stepmother, Letitia Stout, was arrested, I think, in March. So it wasn't this long of an investigation. Yeah. And then you have to also remember that Chaffee County, I mean, it's not, Denver, it's not El Paso County, it's a smaller county. So they might not have seen this long of an investigation in their time. So
yeah, I was just curious about that. I didn't know how long you were there. I know of all those cases because I've actually spoken about them. I know Linda has covered the Gannon Stout case quite extensively. But again, when we talk about numbers and we talk about investigations, this is a 350 something day investigation before they made the arrest of Barry. And Chaffee County and all of the law enforcement that was involved in this took some heat. And I know you as a reporter were well aware of it from your social media. We get beat up all the time because people want information. We live in the day and age of the information superhighway. So
We want it now.
yeah, we want it
People
now.
want the info now.
And if you don't give it to us now, we're going to kick your so at the end of the day, we are used to this as prosecutors, as detectives. We know that sometimes the media can be our worst enemy because if things get out that jeopardize the case. Now, most of the media, you guys are great. When we tell you, hey, we don't want this to get out or we can't comment on it, you guys understand it because we're all looking for justice here. We want to bring the bad guys to justice. We want the legal justice system to work fair and impartial. As Joe Murray says all the time, we need to give the defendants the same rights that, we're all afforded these rights under the Constitution. But when you're not getting, Chaffee County gave that one presser with Sheriff Speasy, and that was it. There was little blurbs on their website, and it was driving everybody nuts. And you know what? Kudos to the people who drove them nuts because their heart is in it for Suzanne. Their heart was in it for all of the victims. They wanted just to get answers. I mean, if some of these moms and dads and some of the housewives and some of the people at their homes, if they could go out and arrest the bad guys, they would go out and do it. I think some of them, but we have law enforcement in place to do that, to do the search warrants, to do the forensic investigation, and it all takes time. I had the medical examiner from New York City, Barbara Butcher, and what a name, right? Barbara Butcher. She was the chief of staff in the New York City Medical Examiner's Office, and she told me, on no uncertain terms, sometimes it takes 6 to 8 weeks and up to 8 months to get back tox, to get back all of the labs, because it goes out and goes through an extensive process. Now, you try to tell somebody that has no experience about that and their loved one is dead, that you have to wait, and they go nuts. People just, you want answers and you want them now. So
yeah, one of the questions I had for Sheriff Speasy and any of the investigators was, when did this turn into a homicide investigation? Because throughout the 11-12 months, it was always she was a missing person. And then finally we get on May 5th that Sheriff Speasy believes that Suzanne is no longer alive, and it's like, when during your investigation did you decide she's no longer alive? And they couldn't give us that answer.
Right. Of course they can't, because every investigation, you interview folks, right? You interview people, or you come across new information through search warrants and all the different investigative tools that you use. And an investigation that can start out as a missing person, you can interview one person on one day that could lead you down the rabbit hole of potentially turning it into a crime. But if you expose that and you tell the media about it, and you say, hey, we are working now this has shifted. Now that person that they don't have yet, they don't have the concrete evidence that they need, the arrestable evidence that they need, then you could jeopardize the whole thing, because then the person can backpedal and can cover his tracks and cover his or her tracks. So there's so many different things that can ruin an investigation by, we used to say, loose lips sink ships. And Pete, you could talk about that in the prosecutor's office. When we would bring a case to them, they would be like, don't talk about this in the precinct. Don't talk about our search warrants that we're going to do. We used to not even tell patrol as detectives when we would go in to do a search warrant. We would want it to be secret because we were worried that patrol was going to tell a girlfriend, and the girlfriend was going to, it's such a complex thing. So when I was working in the search warrant team in Fugitive, they used to call us the Secret Squirrel Squad, because we would never tell anybody anything that we were doing because we didn't want it to get out. Joe, you know about that.
Sure, absolutely.
Yeah. So
I'm just curious if your family was ever notified that investigators believed that Suzanne was no longer alive.
As far as my knowledge and speaking with the other family members, no, they were completely keeping everything close to the vest. I can say from my backdoor research, the opinion of a retired FBI agent who knew someone on the case. His opinion was that Barry was good for the case. So, but that was early on, and he says they're not releasing anything. So they kept the lid on it very tight, and it was very frustrating for the family. But now I understand, and it's like I said before, I really thank them for all the hours and the time that they put in, and that they finally felt that it was the right time to make a move.
Yeah.
And thank you, Lauren, to you too, because I believe that you had threats. Is that true?
Yeah. Mm-hmm.
I'm so sorry, man. And I just want to thank you for your due diligence and for hanging in there and being a professional at what you do. Seriously.
Thanks.
That's not easy.
Yeah.
Lauren, I can get on a plane and I can be armed in all 50 states. I'll be over there and I will knock some teeth out for you. Don't worry about it. Listen, I got Chris McDonough from the interview room. He's remote from a remote location. He's over traveling. He's with his wife, Karen, his beautiful wife. So I'm going to add Chris into the stream. Thank you for joining, Chris McDonough. Where are you, brother? Where are you?
Chris.
I am. Hey, how are you, Tommy?
Hey, buddy.
Hi, Lauren. Hi, Linda. Hi, Joe.
And,
Nice to meet you, Pete.
Pete
Nice
is
to meet you, Chris.
he's my retired prosecutor. So we talked earlier, me and Chris. So I kind of gave him a little background on you. He's got a great YouTube channel. For those of you in the chat, I don't have to introduce this guy. 27 plus years as a homicide detective, 13 years as a squad guy. Chris from San Diego in that area. He's done God's work, and he's worked on some high profile cases. I know everybody knows Chris, but welcome and thank you for taking out the time to come on with us.
Absolutely. And you want to hear something really crazy? How the universe is on schedule. So I'm in Bend, Oregon, just driving down the road, and I look over, and I go, "That's Jared from Adventure with Purpose." And I tell Karen, I said, "That's Jared." She goes, "No way." I said, "That's Jared." And sure enough, it was Jared. So we just spent an hour with Jared just hanging out and having a little chit chat just by total randomness.
Wow.
I run into this guy. So anyway, it was fun. So how are you? Good to see everybody.
We're all doing good. We're just having a little chit chat here. We're about an hour into this. But yeah, I know you said you had some specific questions, and I don't mean to just dive you right into this, but I know you got limited time. Your Wi-Fi might cut out on us at any minute. So if you had a question for Pete, I think it was important. You and I spoke about this. I think it was count 2 that you wanted to talk to him about, right? I'll let you take it over.
I think count 2, Pete, my thinking is, why would the prosecution go so far out to, just kind of add the charge sheet where, they specifically laid out elements of potential mutilation, etc. What's your thought process on that?
Well, I would think that they have some substantial evidence of the fact that the body was mutilated, destroyed, concealed. And it could be scientific in nature. It could be a witness, or it could be a combination of witnesses. But absolutely, I agree with you that there has to be something that they would, put themselves in a corner.
Yeah, I have to agree. And to be honest with you, the body, there's no body been recovered, so it's obviously been concealed, and that's a consciousness of guilt. If they can tie him to the concealing of this body, why else would he do that? I mean, that's textbook. He's trying to hide and cover up.
Yeah, I also came up with and Tom, forgive me because I know you're on the line here, but I have another theory that I think, I hope I'm wrong, but the theory is, there's a bag of corn in play here, right? And it's a 50-pound bag of corn. Well, what I've done some research and learned is that black bears eat every single kernel of corn. And I found it interesting that the animal story was introduced. And I thought, wow, if hypothetically the victim was, dismembered or mutilated, and this corn was utilized to mix in the, different parts, and then thrown out into the wilderness, that black bears in that region would that they ran into if it was also mixed with that feed. And under the guise of turkey season, which I thought was pretty interesting, that this had come up. And I know, Lauren, you know more about it than I do. I heard about it through other reasons, and you can elaborate a little bit more. But at the same time, I thought more and more about this. There had to be a logical explanation other than turkeys. And then if you do a YouTube, if you even just do a YouTube search on black bears and corn, you will find some very interesting things that came up. So anyway, I hope I'm wrong, but I just think that's an oddity in of itself.
I mean,
okay,
I
I've just
agree.
lowered everybody's property value. So
I heard that. I heard that theory too, or that rumor. I've never spoken about it publicly, but that is an extreme possibility. And as we know, Barry's background is the extreme hunter, right? And he knows everything about that game. So, these are real and present possibilities. Pete, you think that there's a chance the prosecution and the investigatives, the investigation could reveal with these strong charges and the strongly worded, when I read it out to myself, I had to read it like 3 different times to really totally understand it. But I mean, they're spelling out some, extreme possibilities here. What's your thoughts on it, Pete, as a prosecutor?
Well, absolutely. But remember, there is a time limit for how long they can delay, because at some point the defense is going to ask for that bill of particulars, and the defense does have the right to hearings on the validity of the search warrants. So at some point, those search warrants are going to be disclosed, and the evidence behind those warrants is going to be disclosed. And it's just a matter of time. The fact of the matter is that they're entitled under the Constitution to contest the validity of the warrants. There's 135 search warrants. That's a lot of contesting that's going to happen in this case, and a lot of opportunity for the media to really roll up its sleeves and crunch the facts. So I think we're going to know. Everything now is speculative because it's essentially a bones and skeleton complaint. But you're gonna get details pretty quickly.
I think strongly that DNA and that type of forensic evidence is going to come into play here. And Tommy, again, I told you before we went live that we were going to have a candid conversation. So, with all respect to you and your family, we have nothing but love, and our hearts are in the right place here.
No, I know you guys all are in the right place. That's one of the reasons I'm here. Is
yeah, yep.
I've kind of, it hurts, but
right.
Got to keep logical about things and a little bit of subjective. I got a question for Pete.
Yep.
Peter,
yes, sir.
I know this is a very difficult question to answer. It's so subjective, but how long do you think this trial could last?
Well, that depends. I mean, I would have to see the search warrant, but I would say we're talking about at least 2 months. At least 2 months. The jury selection could take 2 months by itself.
Right.
And I'm only speculating, but it's a circumstantial evidence case, which means all the evidence will come in like a puzzle. Which many times the trials, that's what happens. But even more so, because the prosecution is going to have to link everything especially when no body has been found. So, you know, and that's one of the reasons why the, you know, the, you know, you know, first inkling would be not to disclose the warrant. So it sort of surprises me that they're not, you know, fighting for non-disclosure as opposed to, you know, supporting disclosure of it. It doesn't really make sense to me, other than that they want to, you know, put the evidence out there because it's a lot to digest.
Thank you.
Yes. Again, you know, I struggle with this quite a bit because, you know, you look at the defense wanting to suppress any and all for good reason. They want to be able to select a jury of the peers. They want to be able to have this here in Salida. They don't want to take it and move it out. But then you have the prosecution, Pete, that is all for release. So have you seen that in some of the heavies that you've been on? And I know you've been on quite a few heavies.
No, as I indicated, you know, we would usually oppose disclosure of a warrant because it usually wasn't in the best interests of anyone. You certainly don't want to have to retry a case because of a you know, fair trial, constitutional jury trial issue. So we would err on the side of caution.
Right.
So there's a lot of other things must be going on, but you know, you have a little inkling when they tell you it's 135 search warrants.
Oh,
That's,
yeah.
That's a huge statement right there.
Lauren, how's the line of communication between the press and law enforcement in the county there? Are you getting stuff from the feds or the state, or is it coming straight from the sheriff?
As far as information updates on this case right now?
Yes.
Since the arrest, it's kind of been quiet in regards to any press releases. I am aware that they plan on doing some more searches, but as far as when and where they'll do them, they have not released that information.
Okay. And do they have like a public information officer, or is it small enough at the department where you just go and you speak to the chief?
Yeah, so that was a great question. From the beginning, we were told just to speak with Sheriff Speasy, and then it kind of switched to the CBI PIO, and then it switched back to the sheriff's office. Since the arrest, I've been, you know, texting the CBI spokesperson, but she hasn't really responded as far as this case goes. So I think they'll probably let us know after the fact if, you know,
Right.
if they do find stuff. So.
And all along during the 350 some odd days leading up to Barry's arrest, what was the and I know, you know, you don't have to answer this, but I know it's in the past. But what was the communication lines? Were you equally as frustrated as the general public and as us retired law enforcement professionals were? Or did you were they dribbing and drabbing stuff to you along the way, or did you guys have to just go with it?
It was frustrating. I would send them emails just to get information as far as how many tips they've received, if Suzanne is still missing, or is she considered, you know, endangered, or is this a homicide case? I was trying to get just any tidbits of information, updates throughout the year-long investigation. It wasn't really until the very end. Well, it was before Andy's search where I did get a personal email from Sheriff Speasy where he did say, like, thank you so much for your attention to the case and bringing awareness to the case. There's just, if I were to do an interview with you, he said that he just would say I couldn't answer any questions.
Yeah.
So
you were equally, it's safe to say you were equally as frustrated as the general public as well, because I know you have you've invested a lot of time and, you know, you're on this. I mean, your coverage is top notch in my book. And I've been around a lot of, you know, East Coast reporters, and, you know, they're very aggressive, and I tip my cap to you several times, because the reporting that you're bringing is just, you're giving quite a bit for everybody that's at home and across the world. You know, you have a worldwide audience, and thanks to YouTube and thanks to social media. And Chris, you could speak to this of how people speak about Lauren and the various coverages that you know, the stories that you're putting out are just instrumental in keeping everybody up to date. So kudos to you. And I appreciate you being candid with us about the level of frustration that you experienced.
Thanks. And I there's still so much information that I haven't released, and there's some interviews that I've done that I want to release. And so hopefully, since the summer, it's going to be a lull season because, you know, that affidavit is going to be sealed until the end of August. I hope to release some more information and some more audio or video interviews that I've done.
Excellent. Excellent. Hey, Linda, do you have anything for Lauren? Because I don't want to hold her here forever.
No, great job, Lauren. I've been watching you all year. I did get your email a while ago. I tried to get back to you, but I think you probably were, you know, overflowed with a bunch of stuff. So maybe one day we'll talk. But
yeah, I love that.
And Lauren, thank you so much. Or, excuse me, Lauren, thank you. And Linda, thank you. And Linda, I see you have Suzanne's picture back there. I really appreciate that.
I do.
Very sweet. Thank you.
Yeah, look at it. She's got a lot of pictures back there. I got you on full screen. Yep, there's JJ.
The sad part is when I started putting all these pictures up, everybody was still alive. They were just missing. Right. So unfortunately,
yeah,
right.
Most of the shelf is, yeah.
Yeah, but you know, it's a testament to your respect for the families and the victims, and I love that you do that because it really means a lot to these folks. Tommy's here and he's telling you right here on the live stream. It means a great deal. And I say this a lot to the content creators and all the folks that are out there, because we have walked the walk and talked the talk, guys like Chris and myself and Mike and, you know, the retired law enforcement. We were the people when we were active that went to these families and had the bad news to give to them. And Joe can tell you too, from first-hand experience, in the New York City Police Department in 1991, we had 2,200 murders in our city. That's in 5 boroughs within a very small geographical area. 2,200 homicides in 1 year is an astronomical figure. And during the course of that year, I had to make quite a few death notifications, and it's not an easy thing to do. So I have compassion and, you know, respect for these families. And that's what you're showing right there in the background, Linda. So kudos to you for a job well done with that. If you guys don't mind, I want to look at some of the private chat. I have a question that's coming in for Joe. So do you believe that Barry Morphew's attorney made the affidavit 130 pages on purpose? Why isn't there a stopping point, and is it reasonable? I know we touched on this. Is it reasonable since it's going to be redacted? And who decides what is deleted and what is fair? And that was a question from Black Rose 11. You're muted, Joe. You're muted. All right, there you are.
The affidavit we're talking about is submitted on behalf of law enforcement. Law enforcement has to swear to the facts that are, you know, of evidence showing that there is a likelihood, first of all, there was a crime committed and that it's likely to find evidence of this crime at that location. What we were talking about is the release of that, because there's so much material in it that could be prejudicial, and it even says that it's material that may not be admissible into court. That's what our concern is on the defense side. But it's not coming from Gary's team. That affidavit comes from law enforcement.
Thank you for that. Yep, I hope that clears that up for you. I'm just looking at the chat because
Can you answer the other question as far as how does the defense decide what gets redacted, and how does the prosecution decide what gets redacted?
Well, usually what happens.
Go
ahead, Pete.
I was going to say, usually what happens is the affidavit will be handed to the defense and the prosecution, and they'll be asked to give their comments, and you'll hand it back to the court, and the court will decide as to what is prejudicial, what's not too prejudicial, what's admissible, what's not admissible. But the court will take both sides, submissions, and then the court decides as to what the evidence and what the law requires.
Thank you for that, Pete. Chris or Linda, does anybody have any questions for Pete? Because I'm going to open it up to the chat in a few minutes.
Actually, I do. Chris and I were talking on his channel there last week, I believe it was, and it's something that many people are asking about, and it's about the wording in the motion of protection of alleged victims, meaning the daughters. I've covered the Gannon Stout case. This is very different here, and maybe Pete, you could just talk about this and how it is different, if this is normal or not, and how it's going to look different, I guess, down the road.
Well, all I could talk about is my experience in New York State, which is that all these factors are taken into consideration, but the paramount factor is the defendant's right to a fair trial. And if the information disclosed would prejudice the defendant to such an extent that the court believes his right to a fair trial would be impugned, then it will err on the side of caution and not release that information. But as I said before, there's going to be a hearing. There's going to be a Franks hearing on all these search warrants to determine their validity. And at that hearing, the defense is going to make its application to throw out the search warrants, or to minimize the search warrants, or to determine that the credibility of the affiant police officer has been questioned. So all that goes into a Franks hearing, and the defense will have its time to beat up on the affidavit and the police officer, who's going to have to take a witness stand and testify as to what the probable cause was for the search warrant. And then the court is going to have to determine whether that police officer is telling the truth or not.
Yeah, and if I can just dovetail into that, I think what I saw into this was that they threw the whole kitchen sink into the affidavit versus, the probable cause for the arrest. And I think the judge's, reading of that was, to your point, both Pete and Joe, and what we were talking about, Linda, as well, that when the judge was reading it, he was like, well, a lot of this probably isn't going to be even relevant, to whether or not it's factual in nature. And so, but I did think it was pretty interesting how the defense, and quite skillfully in their response to the court, said that the girls were victims under the Colorado rules of evidence. And when I looked it up, in my opinion, they're victims of circumstance, no doubt, no question about it. And we should treat them with all, due respect and concern, and be relevant to that. But the only victim, in my opinion, in this case, is Suzanne Morphew. And everybody else is a victim of her death. And I think the defense, quickly tied that into Barry, which I thought was a pretty slick move, to be honest with you, with the way I read that affidavit.
What do you think, Pete?
And Joe, what do you think, being a defense? Yeah, and Pete.
Yeah, they're both defense attorneys, but what do you think, Joe?
A couple things come to mind. If you're, as a defense attorney, going to consider a motion to change venue, part of the factors are, did the defense contribute to the public, knowledge of the case, poisoning of the jury? So I think they have to be affirmative in trying to, object to the disclosure, because I could see a judge saying, well, you consented to the disclosure, now you're going to complain about it and you want to change venue? You know what I mean? So I think it was smart for them to do it the way they did it, but I think they have to preserve that option.
I agree with Joe. There's a doctrine in the law called waiver, And if you do something that essentially waives your privilege or waives your rights, you've opened the door then to whatever that evidence is to come in. And if the defense is part of the spectacle that were to occur, if the media, show increases, then they can't later argue for a change of venue. So, I agree with Joe that they have to be very careful, and they have to essentially be imaginative and creative to show that they are trying to, suppress the media as opposed to working with it.
Right.
Yeah, I agree 100% on that. Pete, I got a quick question, and this is I'm playing devil's advocate here. We have 6 strong charges against Barry Morphew, but the top charge, first-degree murder, if he was to be convicted, let's say for tampering and not first-degree murder, would we still be looking for him being behind bars for the rest of his natural-born life on a conviction like that? I don't like to even talk about that possibility, but what if we don't get the top charge and we get the tampering? But you couldn't probably get the tampering without the top charge, no?
Well, there's what they call, a verdict that doesn't agree, where there's inconsistent verdicts. That's a legal doctrine that would be an appealable issue. But as far as how much time he would be looking at, without doing the research, I couldn't tell you off the top of my head. But it would definitely cause a defense motion for inconsistent verdict, potentially based upon the evidence. Now, if the evidence comes in a certain way that the prosecution could say that that verdict was substantiated by the evidence, then we're talking about something else. But based upon your question, that could be the grounds for an appeal on an inconsistent verdict.
Yeah, that was a question that came in from one of my longtime viewers, and I saw it on my Discord server, so I wanted to throw it out there at you because, there's so many different people who have different questions. We hope that a conviction on all the charges obviously comes down. That's what we're ultimately looking for, and that's justice for Suzanne and for his actions that we think he allegedly has done. But at the end of the day, the burden of proof is with the state. So, we got to just rally around them, and there's a lot to follow here. I know that, so many people have so many different questions, and I try to pull out the questions or the comments that are so far off and try to correct them with these educational live streams. And with professionals like yourself, Pete, and Joe, and guys like Chris and Linda, who looks at all of the evidence and looks at all of the, the background on these cases, Lauren, with your great reporting, I think we're helping to get the proper message out, because Facebook and all of these social media areas can be quite toxic with lots of misinformation, and that's something that we don't like to do here. We want to give fact-driven, based from professionals like Pete and Joe and myself and Chris. These are the people that you should be listening to on this type of situation and case. Tommy, you've already expressed to me your thanks for the information and the live streams and the conversations that we've had on and off of YouTube. I'm always going to be there for any victim or family members that has questions down the road in regards to these cases. But Lauren, I know you came in on a moment's notice. We talked just briefly today. It was great to have you here on the live stream with us, and I appreciate you being here.
Thanks for having me.
Yes. Chris, any parting words for the troops? You got anything? What are you up to, Chris?
Nope. Everything is. Let's wait for the next chapter.
Yeah, I think I'm going to be coming and visiting you on Sunday night. We'll work out the logistics on that, but I think I'm going to pay a visit to the interview room. I will take a seat, and Chris and I will have a conversation. I'm looking forward to that Sunday night. We'll talk about that, and we'll put it out there in the days to come. I'm going to look quickly at the chat. If those of you who can stay, you could stay. I'm just going to look to see if there's any questions. If you folks in the chat have a question for any of the creators here or any of the professionals, now's the time to do it. I'm going to be looking at the chat while anybody has any last questions for the prosecutor and Joe Murray. You can belt it out while I look. Okay. Pete and Joe, Kat, Jersey Shore, who's a good friend of mine. Thank you for being here, Kat. She said, Pete and Joe, if I was ever in trouble, I would tag team with you in tow. Joe Murray's a great defense attorney. And if I was in trouble here, he'd be the one that I'd be calling. Thank you for that, Jersey Shore. Shelby Mooten comes in with a super sticker, and she says, why were the girls given the chance to read affidavit and digest it and not the other side of the family like Tommy and Andy and Melinda? If that is in fact a true statement, I don't know. Did anybody hear that? Is there any truth to that statement?
I've never heard of that.
No.
I haven't heard of it either.
Yeah. So Shelby, that's a bit of misinformation. You might be looking at fake book a little bit too much, and I don't mean to be snide about that.
I think, sorry, Ron, I don't mean to interrupt. I know Shelby, I think where she's getting that from is the conversation Chris and I had on Chris's show. We were talking about that wording specifically in the motion, and that, Chris is here, so he's going to be able to talk about it too. But we were talking about that in the motion, that specific protection of alleged victims. And I had asked, does that mean about the affidavit that they get to read it and the other family doesn't? So this is where this is coming from. So
okay. Thank
Chris
you for
can maybe piggyback on that too as well. We were just questioning how that would work.
Pete or Joe, you want to talk
Well,
about that?
I will tell you this: if you quote someone in an affidavit, it would behoove you to show that part of the affidavit to that person, so that you can't be accused later on of not having showed it to the person. So there could be a situation where someone is quoted in the affidavit, and the affiant, that is the police officer who applies for the warrant, shows that part of their statement to confirm that that's an actual verbatim statement. I don't know whether that occurred. I'm just telling you what the procedure is.
Okay.
Yeah, and like Pete said, this is all going to be subject to scrutiny by the defense and hearings, so that's certainly appropriate to have somebody who's quoted to make sure it's accurate and be prepared for that.
And the next hearing is August 9th, isn't that right? Yeah.
Yes. Yeah. So August 9th will be probably motion to go forward for a trial date, you think? Or potential?
I would think they would need to file motions, and there would probably be a control date for motions. And they would have to file, the defense is entitled to discovery of all the evidence prior to trial, depending upon what the specific rules in Colorado are.
Right.
So we're talking about ways to go before before trial.
Okay, here's another question coming in. What makes the daughters more of a victim versus Tommy or anyone else, Mormon and the Morphew family? It's a good question, but again, I think all sides of this family are victims, and I mean, that's a loaded question, and I feel that there's no right answer to that. But at the end of the day, they're both sides of the victims.
Yeah, I can kind of answer that. I mean,
okay.
This is, these poor girls. This is their father and their mother. I mean, yeah, of course, the immediate family's victims, but my heart goes out to both girls. I mean, imagine.
Right.
I mean, So.
Oh yeah. Yeah, I got you, Tommy. I'm 100% with you on that. Andy Crayons writes in, there's two questions. Number one, can Barry have random visitors in jail? And number two, totally unrelated, exactly how much trouble would one get into for accidentally throat punching an inmate they visit? Just kidding. Okay, Andy Crayons, I love you. Thank you for that silly second question, but I'll read the first question over again. Can Barry have random visitors in jail? Right now, I can answer that. There's probably no visitors other than his attorney at this point, because he is not in state custody. He hasn't been sentenced. And right now, I think the only people that could probably see him would be his counsel, Counsel, you want to talk on that?
Yeah, they probably could get family visits, or they're limited. They only give you a certain amount per month on certain days. It usually goes by the alphabet. But they're entitled to visit.
Yeah.
They
Is there
still
like
have
a schedule for that? Is it a schedule? Can you have visitors every day? I mean, people want to know.
No, it depends on the facility or the actual institution that he's held in, because they may just not be able to accommodate that. So they divide them up, usually alphabetical, A to L, M to Z, even days, odd days, something like that. But you're only allowed a certain amount of visits. Council visits are usually unlimited, but family visits are limited.
Okay.
And unless the prosecution has made a motion under seal to limit visits for some reason or other, and we don't know all the sealed orders that may be applicable to this case.
Right.
Yeah, I'm sure there's a lot.
The reason I said that right away is I've locked up gang members in really bad situations, and they were not allowed to have any visitors while the case was going on. And Pete, you could talk about this. When I was in fugitive enforcement, and we rolled search warrants on a lot of the guys that we locked up, and we said, hey, look, you're facing a lot of serious charges here if you give us up some stuff. So I've had some really bad folks that I put away, and I know for a fact, because I was in close with the cases, they were not allowed to have any visitors. And that's why I said that, and I jumped on it because of my experience.
Absolutely.
I believe Barry is having visits from his daughters and a preacher as well.
Okay. And again, that's going to be varied from facility to facility. I know, here in New York City, it's a little bit different. It's run a little bit different. And everywhere you go, you get a little bit of something different. So
I think also because of COVID, it's video chat or whatever.
Right. All right. I'm scanning the chat. It doesn't look like there's many more questions. The guys and girls who are sending in questions about Chad Daybell and Lori Vallow, that's not what this live stream is about. So I'm not really going to get into those questions here. I like to keep it specific on what we're discussing, the topic. So please understand that. I'm not being rude. I'm just not going to answer those questions. It's not what we're talking about. All right, guys, I think we're going to wrap it up. I think we've covered everything. Tommy, all of my love and respect, as always.
Thank you.
The community that I've built here it's an extension of Linda's and Chris's. We all have respectful, caring and loving viewership that really, they really put it they put all themselves into these cases, and your sister has won the heart of not only America but the world, and that's a testament to the great woman that she was. And I got to say, you should keep your head up high and proud, along with Andy and the whole family, the girls. What a terrible situation, but what a light she's shining here. So I can't say enough good. Linda, you got any final thoughts?
As I say in my channel all the time, when it comes to this case, we won't stop. So
justice.
We're going to continue. Yes, absolutely. We'll continue to keep moving forward and doing what we can to help.
We lost Chris. I was going to go to him next. Lauren, anything for your fans, your troops? You have a great YouTube channel, and you're doing a lot of great stuff. Anything you want to put out there for your following and your friends?
Well, thanks for giving me this opportunity. Just today marks 13 months since Suzanne Morphew was reported missing, and just want people to remember that, she is still considered missing, and that she still needs to be found. There needs to be closure for the family, for her and the daughters as well. They both were seniors. One graduated high school, one graduated college, and so it was a monumental year, and now they're having to go through this with their father being accused of murder. So just keep them in your thoughts and prayers, and just thank you so much for having me on your show.
It's a pleasure, and thank you for that. Chris, you got anything for the troops? Chris? Your mic is muted.
Yep. Yeah, sorry, Ron. I've my internet's gone wonky. I apologize. Here in the woods, as you can see behind me.
I got your audio. We got your audio, so you're good. Oh, there's the dog. Lauren just took a little pup up. Hey, and Tommy, everybody was commenting about the cat all along. So, yeah.
Yeah, that's Rib, R-I-B.
Rib.
Skinny as a rib.
Lauren, what's your pup's name, Lauren?
My dog is a rescue, and I found him underneath my last station's radar, so I named him Radar because he has really big ears too.
Is he a corgi chihuahua? He's part corgi, right?
He's part Jack Russell Terrier and Chihuahua mix.
There you go.
It did have a resemblance to the corgi. The face is just a little too short, but very interesting. Yeah. So thank you to my esteemed guest, Peter Crusco. He has a law firm out in Farmingdale. I'll link that down below in the description. Linda from It's a Crime, I'll link her channel. I'll also link the interview room. Two fantastic folks. I don't have to, tell you guys about them. You guys all know. I'll also link Laure Scharf's, all of her social media. It's going to be, Josh, get ready to work at the end of this live stream. We've got some editing to do. Joe Murray, you're already on my website. Go over to DutyRon.com for all things DutyRon, and all of my guests get a spot on my website. I'll include Linda's link to her channel. Do you have a website, Linda, or no?
I'm working on it. It's going to be itsacrime.com.
Oh, that's going to be
paid
great.
for. It just has to get up.
That's a great thing.
Just one of me.
Yes.
Yeah.
Thank you, Andy Crayons, for the super chat. I want to say a special thank you to all the super chatters that I missed. I apologize. That's not how I usually get down, but tonight was a very important show, a live stream to get information out. So I apologize to the super chatters that I missed and all of the great comments. I will go back and review as I always do. Leave me comments down below. I answer every comment that comes in as long as it's respectful and on point of what we're talking about. So I do respect all of my viewership. The replay viewers are tremendous. I love and respect the live and replay viewers. Thank you. Thank you, everybody, for interacting. Joe, Pete, Linda, Lauren, Tommy, Chris, I can add him back. This is like
thank you to all you guys, too. Chris, Linda, Peter, and Joe.
Yeah.
Thank you.
Oh, my goodness. All right. He dropped out. So he's having internet issues. We got to, you know what? Maybe we could do a GoFundMe and we can get him one of those satellite internets. We could put it up on the top of his camper, and we could get that like round thing that spins around. And yeah, we got to work on that. But anyways, we love you, Chris. The interview room, I'll be on with him Sunday night. I don't know what time, but I'm going to be hanging out with Chris. I'm hoping he's got good internet. Otherwise, my head's going to explode. But guys, as I like to end all of these streams, God bless the world, God bless the United States of America, and God bless each and every one of us here in the chat. All victims of crime and their families throughout the globe. I thank you from New York City, and good night.
Good night.
Night.